Hello and welcome to this session in which we will discuss the statutes of fraud. The statutes of fraud is a legal principle that's requiring certain type of contracts to be in writing in order for the contract to be enforceable. Remember, we talked about for a contract to be enforceable, we have to have an offer and acceptance, we have to have a mutual exchange of legal value, and there should be no defense to the contract. Certain contract to be enforceable, basically we're going to have to add an additional requirement is they have to be in writing. They have to be in writing. Not all contract need to be in writing, but there are 6 situations, 6 specific types of contract where written documentation is essential. So a contract will be good. It doesn't have to be a formal contract, but some sort of a written communication. We would look at the specifics at the end. So first we are going to be discussing those 6 types of situation where a written communication is essential for a contract to be enforceable. We want to have an enforceable contract. This way, if we go to the court, we can enforce it. We can enforce our position. We can make the other party perform. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, FarhatLectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
The first scenario is when you have a long-term contracts. What's a long-term contract? Any contract that cannot be completed within a year. 5-year contract, like for coaching contract, needs to be in writing. Contracts needing over a year to be completed must be in writing. This is what we are saying here. If completion within 1 year is possible, then you don't need that contract to be in writing, or you don't need written documentation. The 1 year period for contract enforceability begin at the contract signing, not at the start of the work. So you will count the year from when you signed, not from the start of the work. That's one situation. Contract involving marriage. These are arrangements where one party promises something valuable in exchange for marriage, such as promising to buy a house if the other person get married. If that's the case, for that contract to be enforceable, it has to be in writing. So make sure you are aware of this. Real estate contract. This includes any agreement related to buying or selling or leasing land, houses, building for more than a year. So anytime you want to buy a house, purchase a house, always the case, buy a building, but if it's leases, the lease has to be longer than a year. So just bear in mind, lease of a land for less than 1 year don't have to be in writing. Otherwise, if you're buying a property, home, land, well, have it in writing. A lease, if it's longer than a year, lease longer than a year, we go back to long-term contract, right? It has to be in writing. This is the third situation. The fourth scenario is sale of goods over $500. Contract for selling goods, movable goods, worth $500 or more require a written document. Now, if the contract is changed later, so let's assume you have a $500 contract, then it's changed later, or you have less than $500, then it increases. If the contract changed later, the requirement for the written document depending on the terms of the modified contract. If the contract becomes more than $500, so you had a contract where you are purchasing something, the whole contract you are buying 5 items, and the total is 5 widgets, whatever you are buying, and the total is $450. Well, do you need a written document? No, but let's assume you increase the contract to 7, and now the price is $650. It changed. It's more than 500. Well, you need a written communication, written contract. If it became less, no need to. Then you don't need a written contract. Now, bear in mind, sale of land and long-term service contract, those must be in writing regardless of the amount. So be careful on the CPA exam when they have this number, this magic number 500. If it's for land or if it's for long-term contract, services more than a year, then it has to be in writing, because they will try to trick you, to confuse you, whether the 500 is for the sale of goods or for something else. If it's for the sale of goods, it has to be more than 500. If it's the sale of land, it does not matter. You need it in writing. If it's for a long-term service, more than a year, it has to be in writing. Fifth, surety contract. What is that? It's an agreement where one person agrees to be responsible for another debt or obligation. Then you should have this agreement in writing. So if you guarantee the debt of another person, you are responsible for their debt. It's called surety contract. We'll talk about that in a separate recording. Executor's contracts. When someone handling an estate's promise, basically when someone passes away, someone handles the estate. They want to use their personal fund to pay off some debt of the estate, because the person that passed away, they might have some debt, and this person is making the payment. That agreement must be in writing. What else do we need to know about the Statute of Frauds? A formal contract is not necessary. So when we say must be in writing, it does not have to be a formal contract. Any written evidence containing the essential terms of the contract signed by the party being sued. So the party that's being sued would have to have their signature on the paper, not necessarily the other party. And that's sufficient. That's sufficient. If you're suing the other party, they have to have their signature. This could be a letter discussing the contract, or even a way to attempt to cancel it. Well, attempt to cancel it is a form that a contract exists. For contract involving the sale of goods, the written must include at least the quantity of the goods and the signature of the party being sued. So if it's the sale of goods, remember, for the sale of goods, all what you need is the quantity. The court can fill in the rest. The contract terms can be spread across multiple documents. They don't have to be in a single document. So you could have email, then a PDF file, then another document, written document, then another fax. But all of them together, they could constitute a written communication for this contract. Not meeting the statutes of fraud written communication does not mean the contract does not exist. It simply means the contract cannot be enforced in a court by one or both parties. Simply put, if it's statutes of fraud involved in the 6 situations, a contract exists. Simply put, the court says, I cannot enforce it because it's not following the legal requirement. Let's take a look at this multiple choice questions from farhatlectures.com. Which of the following contract generally does not need to be in writing to be enforceable? So we have 3 that will have to be in writing, and 1 does not have to be in writing. Which one does not? A contract to sell a car. A car is a movable goods for $600. Does it have to be in writing? And the answer is yes, because it's greater than $500. It has to be in writing. So A is out. A contract to lease a condo for 18 months. 18 months is greater than 1 year. It's a long-term contract. It has to be in writing. A contract promising to pay someone else's debt. That's a surety contract. That has to be in writing when you promise to pay someone else's debt. By process of elimination, these should be the answer. But let's make sure. A contract for a job that can realistically be completed in 10 months. 10 months is less than 1 year. It doesn't have to be in writing. What should you do now? You want to go to Farhat Lectures, look at additional MCQs. That's going to help you understand these concepts better. Whether you are a CPA exam candidate, an accounting student, invest in yourself, invest in your career. Farhat Lectures is here to help you. Good luck, study hard, and of course, stay safe.